Dear students, welcome back to your educational channel Learn and Educate, where we were studying Code of Civil Procedure 1908 under Section 135, Exemption from Arrest under Civil Process. No judge, magistrate, or other judicial officer shall be liable to arrest under civil process while going to or residing in or returning from the court. Judge, magistrate, or other civil officer shall not be liable to arrest under civil process when they are going to his court, when they are presiding in the court, or when they are returning from this court. Subsection 2 states where any matter is pending before a tribunal having jurisdiction therein or believing in good faith that it has such jurisdiction, the parties thereto, their pleaders, muktars, they are the judge in the 19th and the early 20th century, revenue agents and recognized agents and their witnesses acting in obedience to a summons shall be exempt from arrest under civil process other than process issued by such tribunal for contempt of court while going to or attending such tribunal for the purpose of such matter and while returning from such tribunal. Subsection 3 states about nothing in subsection 2 shall enable a judgment debtor to claim exemption from arrest under an order for immediate execution or where such judgment debtor attends to show cause why he should not be committed to prison in execution of a decree. Thus, an judgment debtor shall not get exemption as defined in subsection 2 on the ground of a show cause or shall not commit to prison in execution of the decree. Section 135 states about exemptions of member of legislative bodies from arrest and detention under civil process. Subsection 1. No person shall be liable to arrest or detention in prison under a civil process. A. If he is a member of either House of Parliament or 2. Is the member of the Legislative Assembly or a member of a Legislative Council of the state or is a member of the Legislative Assembly of a Union Territory during the continuance of any meeting of such House of Parliament or as the case may be of the Legislative Assembly or the Legislative Council. This states that any person who is a member of the Parliament, who is a member of House of the Parliament, who is a member of Legislative Assembly or the Legislative Council of a state or is a member of a Legislative Assembly of the Union Territory cannot be arrested during the continuance of a meeting of House of Parliament or as the case may be or of the Legislative Assembly or Legislative Council. B states if he Clause B states if he is a member of any committee of either House of the Parliament, if he is a member of a committee of the Legislative Assembly of a state, or he is a member of any committee of the Union Territory, or he is a member of the committee of the Legislative Council of a state during the continuance of any meeting of such committee, if he is a member of either House of the Parliament or a Legislative Assembly or the Legislative Council of a state having both such houses during the continuance of a joint sitting, meeting, conference, or joint committee of the House of Parliament, then such House of State Legislature as the case may be, and during the 40 days before and such meeting, sitting, or conferences. Subsection 2 states a person released from detention under subsection 1 shall, subject to the provisions of the said subsection, be liable to rearrest and to the further detention to which he would be liable if he had not been released under the provisions of subsection 1. Thank you for watching.